the end of each segment to see if there are any, questions that we need to go ahead and address. So if you have a question, go ahead and type it in the chat, and Tanya and I will try and keep track of it and then probably answer those at the end of each segment. So let's go ahead and get rolling. And Tanya, if you could go to the next slide. There we go. So these are our 3 segments that we're going to go through. First is just going to be an estate planning overview. What it is, what documents are typically included in that, what documents could be included but are not always included. The next part is going to be making decisions about your wishes. So that's a little bit more of the nitty-gritty of how do I think through these various decisions that I need to make? What kind of considerations do I need to take into account? Hopefully offer some helpful information in there because it can be difficult to make the right selections. And also deciding kind of what legacy you want to leave behind, for your family members, and then those causes that are important to you. And then the last portion is going to be about long-term care planning, which we're not going to spend a ton of time on because that can be a whole hour unto itself. But as an elder law attorney, I would be remiss if I didn't talk about that because it 100% relates to how you do your estate planning and also what type of professionals you work with when developing your estate plan. Everything in the presentation is specific to North Carolina. So for those folks who are in other states, that is the beauty and also the headache of having 50 different states is we have 50 different laws. And so there are things that are generally applicable for any estate plan, but in terms of specific documents, signing requirements, things like that, they can and do vary quite a bit from state to state. So just keep that in mind. All right. So first, what is estate planning? And this is something that I get all the time. People will call in and say, I want to do a will, period. They don't say anything else. And we say, okay, so you need an estate plan. And they go, no. I don't have millions of dollars. I don't need an estate plan. Estate planning is not meant for people who are just very wealthy. Really, all that you should hear when you hear the term estate planning is I'm planning for my incapacity and I'm planning for my death. What's going to happen with my stuff when I pass away. And that's really it. And that's something that applies from folks who are 18. You have to be at least 18 in North Carolina to sign these documents to those who are over 100. It doesn't matter. All of us, regardless of age, regardless of health, regardless of circumstance, could have unforeseen events happen to us that could incapacitate us, or we are all going to pass away. Death and taxes find everybody, right? And then the last portion of the considerations when diving into estate planning and not shying away from that term is that the documents are typically prepared by an attorney, but there are DIY options available that you can do online. The reason that I say to use caution in that is that you don't know what you don't know. And so it's easy, if you say, well, I just need a simple will. I want to leave everything to my wife, and then I want to leave everything to my kids, which sounds really easy by itself. But if you're working with a qualified professional, they're going to ask you a lot of questions. Sometimes it can seem really invasive. We have a very detailed questionnaire, as do most estate planning attorneys, that asks for lots of information. Do you have a child who passed away before you? Is there a child or grandchild who is disabled? When you start diving into those questions, you may have someone say, oh yeah, my granddaughter receives SSI and Medicaid, and I was going to leave her money. Well, there is a certain way that you have to do that so as not to negatively impact those benefits that that granddaughter is eligible for. And so that's one of those things that if it's not a world you've been in, you're not going to know if you're just clicking through prompts, on a DIY software somewhere. So it's something to just keep in mind that it's important to work with qualified professionals. I think it's a lot cheaper to pay an attorney up front to do it properly than it is to try and fix it after the fact. So as much as attorneys love work, I can tell you right now, we're all busy. We don't need more of it than we have to have. It's easier to do a good estate plan than to worry about fixing it after the fact. And there are options out there that will let you work with an attorney without actually paying a lot of money. If you meet certain eligibility criteria, your local legal aid, or in our area, PISDA Legal Services, may be able to help connect you with an attorney who can help you with that. Another great resource is State Employees Credit Union. They offer estate planning essentials program where I can't remember the amount, it's $500 or something to do an estate plan. And they have attorneys that they work with to do that. And so I would urge you to work with an attorney for this, and also to make sure you're finding the right type of attorney. If you've been diagnosed with some sort of terminal condition, or your spouse has, or you have family members who are receiving disability benefits or could receive those benefits in the future, then you want to work for folks who have a more specialized area of knowledge, like an elder law attorney. And so, the days of old where that lawyers sort of did everything. Everyone was a general practitioner. They do a little criminal law, they do some wills, they do some powers of attorney, they might do some family law. That's sort of going by the wayside, and folks are getting much more focused in those areas. And then some of us, myself included, are board certified specialists in particular areas. And so keep in mind your personal circumstances and try and make sure you're connecting with somebody in your area who's qualified. And if you need help with referrals, my contact information is in the materials. Those are going to be shared after the presentation. You are always welcome to call or shoot me an email and say, I'm in Wilmington, I need someone who can help with elder law matters. Who would you recommend? And I'm happy to refer you to a colleague over there. All right, so now the fun part of all the paper that goes into estate planning. So there are a lot of documents that are included in a good estate plan. And then there are some ancillary documents that can be included, but are not always included. So the first one that I think a lot of folks are probably familiar with, particularly if you've been hospitalized or anything, because they tend to ask you about them in the hospital, or if you go to your doctor regularly, is a healthcare power of attorney. So this is the who of who's going to make decisions in the event that you are unable to make or communicate them. The next is your living will or advance directive for a natural death. And in true fashion of things kind of, working together in life, I was listening to the radio this morning, and an NPR story came on where they were talking about doing living wills. And the person speaking said, I think very appropriately, you have to figure out what living well means to you in order to figure out what dying well looks like. And that's a great way to sort of summarize the approach to a living will is you need to think about what you want your quality of life to be like in an end of life situation to help inform what type of decisions you want your healthcare agent and your family members to make. The next is the durable general power of attorney, sometimes called a general power of attorney, sometimes called a durable power of attorney, sometimes just called power of attorney. This is financial matters. So the healthcare was personal decisions, healthcare decisions. The durable power of attorney is going to be financial decisions, insurance, filing taxes, paying bills, dealing with bank accounts, things like that. Your will, which I think everyone is familiar with. So your will says where things are going to go when you pass away. A trust can be part of an estate plan and is for a lot of people. It's not a requirement and it's not really suited to every situation. And then some less common documents that can be included but are not always included is a HIPAA authorization form. So if you've been to the doctor in the past, 10 years, you probably have signed release forms if you have family members or others involved in your healthcare decisions. And so that is about the release of healthcare information. Another one is an advanced instruction for mental health treatment. If you have had mental health situations in the past, that's a document that you can do that sort of outlines what your care would look like if those situations got to a point where you couldn't make decisions on your own anymore. And then a digital asset consent form. And so right now, all sorts of us have, usernames, passwords, photos that are stored in the cloud, audiobooks. You might have made little movies and things like that. Almost all of us have a digital footprint of some sort with digital assets. And so the digital asset consent form can help make sure that there's sort of a brief form that allows the other people you're naming in your documents to access those assets if they need to.
Kathleen, we have a question in the chat. When should you generate a trust versus just a will in the other documents?
So we will get to that in just a little bit.
Thank you.
And if you'll go ahead to the next slide. All right, so we're going to dive into each document a little bit more and talk about what it does. And then in the second portion of the presentation, we'll get into the how do I pick these people who I'm going to put in the document, but this is going to be more so about what the documents actually do. So the healthcare power of attorney lets you designate one or more agents and successors to make healthcare decisions if you are unable to make or communicate decisions. And there's two things I want you to hear when I say that. Number one is you can designate more than one person to act at the same time. You can have 2, 3, whatever agents. If you have more than 2, it can get, a little bit of a practical hurdle sometimes, but you can list more than one person and specify if those people have to make decisions together or if they can act independent of one another. If you are going to name co-agents, make sure that you're considering who you're naming and how they get along. So don't name the people who are siblings who fight like cats and dogs because you're worried about hurting feelings. This is the time to make decisions about your healthcare matters. That's something you don't want to mess around with and something that you want to be handled smoothly and appropriately. And the second piece of that is that it only kicks in if you are unable to make or communicate decisions. We get a lot of folks who are very worried that the second that they sign that document, they're letting their child or their niece or whoever they're naming to override what their healthcare decisions are for themselves. And that is 100% not the case. This is not a document that automatically hands authority over to somebody else. It's only activated if a doctor has determined that you can't make or communicate your decisions. So I always tell people that could be that you physically can't speak, you've had a stroke or something, and perhaps you're mentally, able to think through those issues, but you cannot speak and you can't write or otherwise indicate what your decisions are. So that would be a situation where you can't communicate it. Another would be if you're unable to make decisions. I've had folks in the past who were able to carry on a conversation, sounded relatively calm, and would say to the doctor, I am not going to take that medication because you are part of the drug cartel and you're trying to steal my land. And so I am not going to cooperate with the treatment that you're advising. And of course, the doctor was not part of the drug cartel, not trying to take the person's land, but mentally something was going on where they were not able to understand what was being told to them, consider the consequences, and then make an informed decision. That is very different from if you are having a conversation with your doctor and they're saying, here's what I think you should do, and here's a healthcare treatment that I would advise that you follow. And you saying, I've thought about it and I don't want to do it. The risks are not worth it to me. I don't want to do that surgery, whatever. The point is, are you able to understand what they're saying to you, to understand the consequences of choosing that treatment or not, and then follow through on that decision on your own? And needing some help from a loved one or from a professional in understanding that does not mean that you can't make decisions. For those of us who are not medical professionals, there are folks that you can hire who are nurses, who are care managers, and can help you understand and sort of navigate the healthcare system. Needing help from someone does not mean that you cannot make your decisions anymore. So needing a little help is just fine. The decision-making authority that's granted in this document is very, very broad by default. So North Carolina's General Assembly in 2007, I think, created a template statutory form for the healthcare power of attorney. And you don't have to comply completely with that form structure, but usually things substantially comply or follow it exactly. And so in that document, it lists all sorts of things your healthcare agent can do, but you can change that. You can limit your healthcare agent's authority. If you don't want them to be able to consent to certain types of treatment, if you want there to be certain considerations about treatment decisions that they might make, you can put that in the document. And so you can customize this to your specific wishes. That being said, I always tell folks not to tie their agent's hands too much unless they really, really, really mean it. If you are going to say my agent can never make this type of healthcare decision, then you need to mean it. Because while you may change your mind down the road, changing your mind and then updating your document after you've changed your mind, but before you actually need the healthcare power of attorney, there may be a gap of time there. And so that's something to take into account. The last part of this is that your healthcare power of attorney is a little bit different than a financial power of attorney in that you can include decision-making authority after your death. So it could be whether to authorize organ donation, authorize an autopsy, donate your body to science, What type of funeral arrangements do you want? Do you want to be cremated? Do you want to be buried? If you want to be buried, is it a green burial? You can set out those wishes in this document. And again, if you're going to put things that are really specific in the document, you need to mean it. You can always update it after the fact, but sometimes I'll get folks who say, here's the type of funeral I think I would want right now. My kids know exactly what I want. Should I put this in the document or not? And so usually I tell people to think about, if their wishes might change, and if they will, you can always do sort of a separate document that's informal that tells your kids, hey, as of this date, here are my wishes. Here's what I want to happen. And that can be changed a little bit more flexibly than you having to update your healthcare power of attorney each time your wishes change about your funeral arrangements. And next we'll go on to the general durable power, or actually, sorry, skipping one. Now we're going to talk about the advance directive for a natural death, which is also known as your living will. And this form can be combined with the healthcare power of attorney. So each of these documents has different signing requirements in North Carolina, but the healthcare power of attorney and the living will both require 2 qualified witnesses and a notary. And so when I say qualified witnesses, there are limits on who can serve as a witness. It needs to be people who are not named in the document, who aren't going to inherit from your estate, who are not healthcare providers. There are restrictions on who can serve as a witness. And then of course you need a notary, which hopefully everyone is familiar with a notary. So our firm combines these documents onto one form. A, because they have the same signing requirements, so it's convenient. B, it's nice to have all of those healthcare related decisions in one place so that people don't lose or misplace a document and then not know what somebody's wishes are. So the living will applies in 3 end-of-life conditions in North Carolina. If you have an incurable or irreversible condition, so that could be something like ALS. If you are unconscious or in a coma, and that would be sort of a natural vegetative state. That's not the same as if you're in a medically induced coma as part of your treatment. And then if you have advanced dementia or cognitive loss. And again, these are only end-of-life conditions. It's only when doctors say this person is suffering from this condition and they're going to pass away in a reasonably short period of time. It is not when you accidentally put your car keys in the refrigerator instead of on the front table when you walk in. No one's going to try and keep food from you, if you have lapses in memory, even if you forget who your family members are. But dementia, if, it progresses to that point and there aren't other health issues that arise, can get to a point where you don't remember how to eat and drink anymore. Your body's not able to swallow on its own. At that point, do you want a feeding tube? Do you want IV fluids? If you're in a condition that may require a ventilator, do you want to receive that ventilator? And so, the question is about what types of medical interventions do you want if some vital bodily function needs to be replaced because it's not happening on its own naturally, or do you want to pass away naturally with no interventions? And so typically this form offers 3 different options. The first is where you authorize, but do not require that care be withheld. And so that means that you're saying to your healthcare agent, I have thought about this. I have thought about an end of life situation. I am okay with you letting me pass away naturally, but I'm going to let you decide at that time, taking into account whatever my doctors are saying at that point. And so you are not requiring that they do something one way or the other. You're sort of deferring the decision to your healthcare agent, but you're telling them, I've thought about this and I am going to empower you with that decision-making authority. That's probably what, I'd say, half of my clients pick, maybe a little bit less, because one consideration may be not just what you want, but the person that you're designating as your primary and probably first backup healthcare agent. What are that person's strengths and weaknesses? Would they actually be able to pull the plug, so to speak, if the situation arose? And some of my clients say, yes, my daughter is a nurse. She gets it, no problem. She would be able to make that decision at the time and it would not be an issue. But I get other folks who say, nope, not a chance. They would never be able to do it. They're going to feel like, they were the one who was sort of leaving me behind. And so that's why a lot of people choose that second option, where they require that care be withheld. And so this is really you bypassing your healthcare agent and saying, I'm not going to give this person discretion. I am just going to go straight to my doctors and say, if I'm in one of these conditions, I'm at the end of my life, let me pass away naturally, withhold any care that may prolong my life. So in that situation, a lot of folks go, well, what if I have family members in, California and Arizona, and they need to get here to see me? On a practical level, I have never seen healthcare providers sort of like rush into someone's room in the middle of the night and start unplugging things. They almost always, for a multitude of reasons, are in touch with the family members, they're in touch with the healthcare agent, they're trying to give people time to come, to say their goodbyes, and also trying to get those folks' consent, particularly the healthcare agent, before withdrawing care, even if the document doesn't require it, just because, I think on a human level, it's important for everyone to sort of be on board and have their chance to come to peace with the situation before a family member passes away. The other part of it is nobody wants to get sued. You have probably seen court cases that end up in the news where a hospital is trying to follow through with one of these documents and somebody's wishes, and a family member or someone else who's involved, opposes what they're trying to do. No healthcare provider wants to be in that situation if they don't have to be. And so there's a practical aspect of making sure that everybody's on board. But that being said, if the family just will not get on board with what you have set out in this document and your wishes, then they have measures that they can take. They have committees that they can form that include the risk management folks, the healthcare providers, ethicists, to move forward and follow through on your wishes. And if needed, have court intervention to make sure that that can happen. And then the last option is maximum treatment, which sort of says, in spite of my attending physicians at that time saying I'm likely to pass away in a short period of time, I want you to give me the maximum treatment you can for as long as you can. And so this is the option that probably the least amount of people pick, but I have had folks select it, particularly young parents who have young kids who want to make sure if there is any slight little chance, that they might recover, then they want to be given that opportunity. And so that's an option that's out there, though it's not the most commonly selected option. And regardless of what your decision is, and regardless of what you set out in this document, it is not going to impact providing comfort care. So pain measures and things like that are still going to be provided to you, even if it's going to prolong your life. So pain measures can be provided, comfort measures can be provided, even if you've said you don't want your life artificially prolonged. As long as it makes you comfortable, then they can still give it. And it looks like we've got two questions that I'll go ahead and address while we're in the sort of healthcare pieces of which of these documents are state specific, and about moving states, which I'll sort of get to in a minute. But all of these documents are state specific. The healthcare power of attorney and the living will are both based on templates that North Carolina's General Assembly has created. I was dealing with a client in California recently, and there, I think Medical Society has created forms. Every state kind of has their own separate forms and different signing requirements for those. And what are the next question is, what are the disadvantages or weaknesses of the 5 wishes document? So for those of you who have heard of the 5 wishes document, it's also really a combined healthcare power of attorney and living will in one form. It has 2 witnesses and a notary. It substantially complies with the signing requirements, and so it's valid in North Carolina. It includes what I consider to be some of the softer options regarding your healthcare. And so you can set out in a little bit more of a narrative form what you envision for your care and what you would like it to be. As a lawyer who's paranoid perpetually about things being followed properly and documents being honored, my primary concern with 5 wishes is that most people seem to fill it out on their own, and I've seen them either fill it out in a way that's unclear, that this is one of those you don't know what you don't know things, where they don't think they've been unclear, but then when a lawyer reads it and says it's really unclear what you mean here, they sort of see it. The other problem is signing requirements. I've seen people who do it on their own and who do not have 2 qualified witnesses, or miss the witness part and think they can do just the notary, even though if you read the form, it's very clear you need to do all 3. Those are the problems that I've seen with those. Early on, the 5 wishes form was not all that common. And so I would have said, healthcare providers aren't as familiar with it. And so you may have just a little practical hurdle of them saying, I haven't seen this form before. I'm going to need to have somebody else in my office look at it. Now, I think it's probably common enough that most healthcare providers have seen it. And so that problem is starting to go away. But my paranoid lawyer self likes forms that look much more closely like what the General Assembly has created, because that's what they, are used to seeing. And that's what probably 99% of folks have who have these documents. And then the last question is, what is considered comfort care? And so that's giving you, morphine. That is making sure that you're getting mouth treatments to keep your mouth moist. For folks who are in end of life situations, they may be unresponsive for a while and then become responsive, and ask for water or something like that, or want to sip on something, making sure that that person has water, even if it's giving them some hydration, that may make them live a little bit longer. And so it's really anything at all that makes you more comfortable and keeps you free of pain. All right, now we can go on to the general power of attorney. And so all of that was healthcare related, almost completely during your life. But remember, there are some post-death decisions that can be made. The general power of attorney is similar in some ways, different in others. So like the healthcare power of attorney, you can designate one or more agents to handle your financial affairs. So again, you can name 2, 3, in theory, 4, whatever people to make decisions. That being said, remember the practical hurdles that you may face with that. Unlike the healthcare power of attorney, it's generally effective the moment that you sign it. And so this form can be what's called springing, which means that you put a provision in there that says this document is only effective when 2 of my physicians have certified that I'm unable to manage my affairs. I don't like those. And most of the estate planning attorneys that I know don't like them. And here's why. It sounds great in theory, to sort of limit your exposure of who can have their hands in your money. But we have seen issues dealing with financial institutions of what they want to be included in these letters before they honor them. And y'all have probably seen, like, this bank will merge with this one, and then they get bought out by somebody else, and then they merge and form a new bank, and yada, yada, yada. And every time that happens, policies change, staff change, there are just lots of issues. And so we have seen a number of practical issues getting those documents timely accepted by financial institutions. And so that sort of doctor letter provision can, if not very, very specific, can present some really obnoxious practical hurdles, particularly because usually a lawyer would do this document up front, but then they wouldn't necessarily need to be involved at the time the document is being used. But folks will take the document to a bank, encounter issues with it if it's springing, and then have to hire a lawyer to help them deal with the bank and get the document actually honored. And again, as much as we love y'all, we're all busy. We don't need more work than we have to have. And so if you can keep it simple for your family members so they don't keep having to go back to a lawyer, needlessly to deal with the bank, then that's helpful. What we prefer instead is to make the document so that it has to be recorded in the Register of Deeds office before it's activated. So you can have it springing upon incapacity, but you could also make it sort of springing based on something else. And so you can say it's going to be effective starting upon a particular date or a particular event. And so in our documents, typically, we say it's effective once it's recorded in the Register of Deeds office. And so that serves as a little bit of a safeguard to make sure that if you are competent and have the ability to manage your affairs, that when that document is being used. It's not going to be activated without you knowing that it is out there and active, or you're at a point where you don't have capacity to make decisions anymore. And then we sort of set out, different options for our clients of when we can release those documents to the agent who's named in the power of attorney and could record it then. Other clients choose to go ahead and record it the moment that it's signed. For those who have estate planning documents that they did previously, particularly pre-2018, North Carolina statutes used to say that when you sign this document, that if somebody who signed it lost capacity to make decisions, the document had to be recorded in the Register of Deeds office. But the banks never had a way, to sort of know if that was the case or not, unless you had a particularly springing power of attorney. And so they would just require that every power of attorney was recorded before a third party would honor it. That law changed in 2018 when North Carolina adopted a uniform power of attorney act so that it no longer has to be recorded unless it's being used for real estate matters. But you can add a recording requirement in it. And that's what we found is sort of the best solution for our clients. North Carolina does have a statutory short form general power of attorney. And if y'all have a power of attorney, you'll kind of know if this is the form you have because it's usually 1 or 2 pages. And it will have a list of powers and a line next to each one that lets you initial next to what you want to allow. We never use those. And barring like the most extraordinarily simple of circumstances, I don't usually advise folks to have them because they leave out a lot of powers that you should give some thought to and be deliberate about. So that includes gifting authority. So there is a gifting line in the statutory short form where you can say I authorize gifts, and then you can initial something else that says including gifts to my agent. So let's say you have named your spouse as your agent under the power of attorney to manage financial affairs if you cannot. And then you also initial that part saying the agent can make gifts to themselves. Well, again, along with the you don't know what you don't know pieces, unbeknownst to you, there is a court case out there in North Carolina that says that that provision still limits you to a prior pattern of giving. So the agent would be restricted to making gifts based on a prior pattern of giving. How many of y'all are regularly giving away money and houses and things like that? Probably not a lot. And so that restriction can be problematic if one of you gets sick and is in a nursing home and needs to qualify for Medicaid, and we need to move assets over to the spouse who's still healthy and living at home. If we have one of those statutory short form powers of attorney with limited gifting authority, then our hands can be bound a little bit in what options we have out there to protect your spouse who is still healthy and who is still at home. Another provision that you should give some thought to is compensation. Should the person who's managing your assets be able to receive compensation for the work that they're doing? And some people say, no, I named my kids, I brought them into this world, I took care of them, it's their turn to take care of me, and that can be a perfectly fine approach to take to say, no, I don't want my agent to get compensation. But again, looking at sort of the long-term care piece of this, it can be helpful sometimes to allow compensation for your agent as another way to make sure that assets are protected for your surviving spouse, if you end up in a nursing home. And so it's things like that that need to be thought through and talked through pretty deliberately. Another one would be the ability to change beneficiary or joint ownership designations. And so if you have bank accounts, you can name POD, pay on death beneficiaries on that account, or you can add joint owners with right of survivorship. There can be a number of reasons to enable somebody to do that. Now, when we include that power in our documents, we limit it to say that those decisions have to be made consistent with your estate plan to make sure that if you've got a will that says I leave everything to my spouse and then everything to my 3 children, that if one of the kids is agent, they can't manipulate things in a way that would leave the assets to themselves as the sole beneficiary. But the point is that needs to be a discussion that's had and some deliberate thought put into it. And those are not things that are covered under the statutory short form power of attorney. And so, something else to keep in mind with this that I should have mentioned at the beginning is a lot of people, and for those of you who don't have an estate plan, I'm going to bet that at least one of you falls into this category, goes, I don't need these documents right now. I will do them when I need them. You don't know when that's going to be. None of us know when we're going to have some sort of health issue occur, when we're going to temporarily or permanently lose capacity to make decisions. None of us know exactly when we're going to pass away. And so it defeats the purpose to say, I'm going to, just do these documents when I need to do them, because you don't know when that is. And so the point is to go ahead and put a plan in place now that outlines your wishes, that you can always change in the future as long as you have capacity, but you should at least have some basic documents. And talking to sort of the lifetime decision-making authority, if you don't have these documents, a lot of people also go, it's not a problem. They're going to let my spouse make my decisions, or they're going to let my oldest kid or my closest kid or the kid who lives with me make decisions for me. No, they won't. There are some default laws that if you do not have these documents and you're in an end of life situation or some sort of emergency, that somebody can temporarily make decisions on your behalf. And there's an order of priority based on family members in that. But that's only meant to cover a very narrow subset of circumstances, and it doesn't cover financial affairs at all. So if you don't have these documents and you are alive but do not have capacity to make your decisions, your family members are going to have to go to the clerk of superior court in your county, file a guardianship petition against you that gets served on you by a sheriff. Another lawyer will get involved to serve as your guardian ad litem and sort of report to the court what's going on in a recommendation. And then a hearing is held to talk about the ways in which you cannot make your decisions. And if a guardian is appointed and they need to manage financial assets, they have to file public reports with the court, an initial inventory, and then annual accountings for the rest of your life or until the guardianship terminates, reporting every dime that is in your accounts, every dime that comes in, and every dime that goes out. Those are all public record. Those are not online yet. They're in the process of moving a lot of those court forms online. And so that's on the horizon. I don't know about y'all, but I don't want my financial information, to be public. And I don't want folks to be able to see all of that. And so by doing these documents ahead of time, you are reducing or eliminating the likelihood that you're going to need a court-ordered guardianship and sort of put your family through that process, which is not only, sort of emotionally costly for them, but is also financially costly for them potentially, depending on whether you have sufficient assets to pay somebody, if they need a lawyer involved, if you're able to sort of fight against that guardianship process, even if you need a guardian, it can get very messy very fast. And again, when you hear messy and you hear lawyers, you should be thinking about dollar signs because it gets very costly very quickly, when things are not going smoothly. And so you can help eliminate that by doing these plans ahead of time. You can also add some safeguards for yourself by considering accounting provisions that you want in the document upon your incapacity. So we usually include a provision that you, as the person signing this document, can get copies of bank statements or whatever else you want to while you're alive of what's going on and what your agent is doing on your behalf, because it's your money. You can also authorize other people to be able to demand those accountings, or you can require that the person file accountings with the court or give accountings to other people. Again, there's all these places in the document where you can customize it to your particular situation and your particular concerns to make sure that everything is covered pretty well. And I'm going to just answer a few questions here. So let's see. So there's another question about sort of out-of-state documents, which I'm going to defer again because I'm going to get to that in a minute because the same rule sort of applies to all of them. If you have a trust, is there a reason to have POD accounts, pay on death accounts? So if you have a trust and your trust is properly funded, which we'll talk about in a little bit, then no, you can't have a POD account because a trust is an entity, not a person, and it doesn't have a lifetime, so you can't have a beneficiary on the account. If an account is in your individual name and you have a trust, then you can name the trust as the POD beneficiary. And one of the benefits that I'll go over with the will in a minute of having those beneficiary designations is it keeps things out of probate. So we'll talk about probate a little bit and what your will does and does not cover in just a minute. Another question was to just repeat what I said about the POD and joint with right of survivorship designations on the short form power of attorney. And so the point there is just that a lot of those statutory short forms either do not address it or do not sufficiently address it. So you need to make sure that in the general power of attorney that you are specific about whether your agent can change your pay on death or beneficiary designations or the joint with right of survivorship designations, and give some guidance or some parameters about how those decisions are to be made, and say it has to be limited to be consistent with your current estate plan to make sure that people are not going to do things in a way that is just self-serving, which your agent under these documents is always supposed to manage things as best they can in accordance with the wishes that you have, if they know them, and also in your best interest. They're not supposed to do things that are self-serving, but people do things that are in their own best interest sometimes. It's a lot more hassle and a lot more headache to unwind that after the fact than to just be clear up front, about how that is done. And if you have a statutory short form, those sort of individual places where you initial refer back to statutes that are in place that are much more detailed about what those powers are. And so if you have one of those forms and you're curious about that, I can find the link in a minute, and I'm happy to put it in the chat so that you can actually read, what kind of power you're giving that person, because it may say, real property transactions, but there is a very specific, more extensive paragraph that talks about what you're allowed to do. The next question is, power of attorney has 2 daughters with equal decision-making power. Should it be a hierarchy order instead? So I know some attorneys who say, don't appoint co-agents ever in any situation, never, ever, ever, because they want to avoid the complication. Usually it's my preference to just appoint one person, because then you're not having issues about 2 people making decisions, but there are a lot of perfectly harmonious and happy, families that are out there. For all the ones that I see that are not, there's plenty that are. And so, your family members best. Do those 2 daughters get along really well? Are they always on the same page? Are they good at communicating with each other? Or are they still talking about and competing over who got the better dollhouse when they were 5? And y'all may laugh, but there are people who still fight about who got what toy when they were little. I am not kidding. So think about that, and think about realistically, how well are these people going to work together? And this is not the time to force people together thinking that some crisis on your part is going to bring everyone to being a better family member. It doesn't. Everyone's going to be under more stress. People act very strangely when they're under high stress amounts. They're bad at communicating. Put everyone at their worst, and then decide if you think even at their worst, they'd be able to communicate well together. And you can also outline, if you do still want to name 2 people, you could say in the event of a dispute, this person's decision will control. And it could be one of the daughters, or it could be somebody else, who can sort of be that tiebreaker. And then another question was, to state residency rather than where you're actually living, determine which documents you sign. Typically, yes. Typically to avail yourself of laws in a certain state, you would need to have sufficient connections to that state. And so usually you're looking at, where do you file your taxes? Where's your driver's license? Where are you registered to vote? And where are you physically present? And so all of those multitude of factors, should be considered. And if you're not sure, that it can be helpful to contact a lawyer in one state or the other to help you determine sort of which you fall into. And I am going to link the North Carolina Uniform Power of Attorney Act. It is long, it is not fun reading, but it does include a list of those powers for those who want to see it. So the first link is just going to be the entire act. The second portion that I'll include is just going to be the actual authority, so that if you want to see when it says, tangible personal property, specifically what those powers are including, it'll outline that for you. All right, now I think we're ready to go on to wills. All right, so the last will and testament. So this is the document where you appoint an executor, a person, or you can appoint a corporation to dispose of your assets after your death in accordance with the terms of your will. This only covers probate assets. Not everything is part of probate. So it's a big misconception that North Carolina's court system is going to be involved in the disposal of all of your property, regardless of how it's owned. And that's not the case. Your will is only there to cover assets where you have not already said where those assets go at your death. So, for example, if you have a life insurance policy and you have a trust and you've named your trust as the beneficiary, or you have 3 children and they are named as the beneficiaries, you have already said with that financial institution where that asset will go at your death. The same is also true of joint with right of survivorship bank accounts or POD bank accounts. You have already said, when I die, this asset goes to these people who survived me, or this account gets closed and gets distributed to these people who survived me. And so you've already said with the asset where it goes at your death. So your will is only intended to cover those things where you have not said where the asset will go at your death. For those of you who have vehicles, if it was purchased, in more recent years, and there are two owners on it, at the time you filled out the title application, you would have checked a box potentially as to whether that car was going to be joint with right of survivorship or not. North Carolina has pretty much always allowed you to do joint with right of survivorship ownership on a car, but they have only made it easy to do that in more recent years. It used to be that you had to know you could do that and put the letters JWROS, joint with right of survivorship, on the actual title. If you have a car that you've owned for a really long time with you and your spouse, if you want to make things just a tiny bit easier when you pass away, look and see how that title was done, because you can always add that right of survivorship even on a car. You have to do it with the tag office, but it can be done. Otherwise, when one owner passes away, if you don't have right of survivorship, then the half that was owned by the person who passed away goes into their probate estate, and the other half remains with the spouse. Now, there's a way to get it over to the spouse fairly easily, but it's a few more steps and a little bit more cost with the court. Another fun quirk of North Carolina law, and a big concern that people have, is my house. What about my house? Is my house going to go through probate? And the answer in a very lawyerly fashion is it depends. If you own your house with your spouse, even if the deed doesn't say joint with right of survivorship, then by virtue of owning it with your spouse, that's a special type of ownership called tenancy by the entireties in North Carolina, and that includes a right of survivorship. And so if you're married and you own a house with your spouse, then almost certainly you have that type of ownership, and so it's automatically going to go to them when you pass away. If you have a life estate that says, I have the right to live here during my life, and then at my death it passes to my 3 children, then that also stays outside of probate. But here's where the fun quirk of North Carolina law is. If you have a will that says, I distribute everything to my 3 children, and you owned your house in your individual name, you didn't have a spouse or a joint owner on it, you were the sole owner, and your will just says, I leave all of my assets to my 3 children. North Carolina law says that title to that house automatically vests after the will's been probated and proven to the court, which I'll talk about in a minute, automatically vests in those 3 children. There is no court supervision process. There is no deed. The only time that would change is if you had more debts than assets at your death, and the house needed to be pulled into your estate to pay your debts. But otherwise, if your debts are paid and you don't have any other issues, tax liens, things like that, if your will says, I leave my house to my 3 children, they automatically have title to it. The will serves like a deed. The will is the proof that those 3 kids are the owner. And again, it happens immediately upon your death. Now, the only way to make it go through probate, and there can be some really good reasons to do this sometimes, is to say, I give my house to my executor and I direct my executor to sell the house and distribute the proceeds among these people. So you can, in your will, force it to go through probate, which can be helpful, because if you have 5 children and you just say, I leave everything to my 5 children, if those 5 children are all married, then if they automatically get title to the house by virtue of that sort of quirky North Carolina law, then when they go to sell it, all 5 of them have to sign off on the sale. And if they're married, all of their spouses have to sign off on the sale. So that's 10 people all agreeing to a real estate agent, a list price, sale terms. The more people you add to that kind of decision, the greater chance someone's going to obstruct it and make it more complicated. And so that can be a reason for putting it into your estate and giving your executor the authority to sell it and saying, I'm going to just, have my estate pay for the probate fees for the convenience of having just my executor, just one person, sign off on that sale instead of having everybody do it. Also, if you have a trust, if you have assets that are owned by your trust, or if your trust is named as a beneficiary, whether that's transfer on death or like a beneficiary on a life insurance policy, then that also is outside of probate, and so that's not trust assets that are properly funded and properly directed to the trust will not be part of probate either. Another important consideration is, when is my will effective? Because, and this is probably not for those of you who are going to do an estate plan, more so for the kids that like to call us about their parents and say, well, I'm executor of my mom's will. And we say, okay, when did your mom pass away? And they say, oh no, she didn't pass away. Nobody is executor until you're gone. When you see last will and testament, I want you to think about the last will part. We don't know what your last will is until you're gone. You can always change it up until the day before you pass away, the day of, your death. It doesn't matter as long as you have the requisite capacity to do so. Some considerations in doing a will is that it becomes public record after you pass away, after it's probated. And so after you die, even if you don't have probate assets, there's some options of what you can do. You can put the will on file with the court, which is not actually having it probated. Probated means the court has looked at it and has accepted it as valid under North Carolina law. And so that's one piece of it, would be to say, okay, it's probated, the court's accepted it, or you can just put it on file so that it's at the courthouse in case it's ever needed. Or sometimes people don't probate the will at all, if there are no probate assets that need to be covered. But if it does get probated, then it becomes part of, or put on file, it becomes part of the public record. And for privacy reasons, sometimes people don't want that. You can also establish a testamentary trust in your will. So a big misconception is that trusts have to be standalone documents, that are separate from everything else that you have, that it can't be sort of part of another document. And that's not the case. Your will can have an article that sets up a trust that says, I leave my assets to my 3 minor children, and they're going to be held in a trust following the terms of Article 4, of this will. You can also disinherit people from your estate plan. Generally, there are some people you can't disinherit, spouses in North Carolina, with some exceptions if you have a prenup or postnup or certain waivers. But spouses in North Carolina generally have a right to inherit from their spouse. And that is based on the length of marriage. And there is a particular percentage based on how long you've been married, and that's called an elective share. And so it's not an amount that automatically goes to the spouse, but it's an amount that they can claim, so they have a certain period of time after you die to claim that amount from your estate. There's also something called a spousal allowance within the first year after death that they could claim, claiming the first $60,000 of property. And so those are things for you to consider, if you are legally married and have not done, but maybe estranged from your spouse and haven't addressed some of these considerations. If you die without a will in North Carolina, another common misconception is that all your money goes to the state, which is not the case. North Carolina has what are called intestate succession laws, where they try and predict, for lack of a better term, what you would do if you had a will. And so it sets out, if you die with a surviving spouse and 1 child, here's what happens. If you have 1 spouse and, well, obviously 1 spouse, but a spouse and multiple children, here's what happens. If you don't have any children, but you're survived by a spouse and a parent, here's what will happen. So there are different scenarios based on who survives you. Sometimes those are completely in keeping with what the person probably would have done if they had a will. Sometimes it's not. And so I always tell folks, doing your estate plan is your chance for you to make your decisions instead of letting the state of North Carolina make them for you, because you don't always know if your wishes are in line with what North Carolina would presume that you want to do. You can also use this document to nominate a guardian for minor or disabled children. So it used to be that you could only do that for minor children. And then the law changed, 4 years ago or so, that allows you, if you are a guardian for an adult disabled child, you can nominate who your successor is either in your will, or you can do a separate document. And you can say, here is who I would like to be my successor after I pass away, if we've not changed the guardianship before then. And a lot of my clients change the guardianship ahead of time, as they start to age and aren't able to serve as guardian as well. A sibling or sometimes a professional agency will take over as guardian so that that transition is already in place for that disabled adult child. And I think we've got a few questions. So one of the questions was, what's the difference between per stirpes and per capita on bank POD accounts, and can minors and disabled adults be named? So if you have a will, or if you filled out beneficiary designation forms, you've probably seen things like per stirpes and per capita. And so what those mean is sort of how you calculate the fractional shares that people are getting when someone predeceases you who's been named. So for people doing wills, per stirpes is the most common of what our clients do, which would mean if I've got 3 children and one of my children passes away before me, my daughter Samantha passes away before me, and she had 4 kids, then when I die, everything's going to get divided into 3 pots. The 2 children who survived me will each get a third. And then the last third that was going to go to Samantha will get further subdivided, among her children. Per capita is separate because it's really meaning you're looking at all of the people who are inheriting, and there's different ways to calculate that at generations. And so you can set it up so that everyone who's inheriting is getting an equal amount, or everyone who is of a particular generation is getting an equal amount. So let's take that same, 3 children situation. And let's say 2 of my children passed away before me, and one of them has 4 kids and another had 2 kids, and then I have a child who survives me. In per stirpes, those children would inherit their 1/3, and 1/3 would be split 2 ways for that one child and would be split 4 ways for the other child who died. But if you're doing per capita, at each generation, you can have it so that all of the grandkids get an equal share. You're sort of taking out a fractional share and then recalculating at that generation so that all people of the same generation would get the same amount. Naming minor and disabled children is another reason to have an estate plan. It can be done. It needs to be done carefully. You can do what's called a Uniform Transfer to Minors Act account, UTMA, which is how a lot of designations are done for minors, where you would have a custodian, presumably that person's parent, to receive those funds and manage them for the minor until they either turn 18 or 21. You can specify that. That can be helpful for smaller accounts. If there's going to be any substantial amount of money, I think a trust is probably preferable, just because you can be more specific about how that's managed and have some oversight there if you need it. Naming disabled adults, caution, caution, caution. If you want to leave money to a disabled adult, you need to know ahead of time, A, if that person is getting any means tested benefits like Medicaid or SSI or housing assistance, food stamps. And you also need to know, even if they're not getting those benefits now, if they might be eligible in the future. And you can build flexibility into your estate plan to hold that money in a special needs trust for that person so that the money is there for their benefit. Someone else would manage it, but it's not going to negatively impact those benefits that they received. Another question was, if there are no assets to be probated, does the will need to be filed with the court and the notice to creditors published? And the answer is no. There is no requirement to open up a full probate. There are different levels of what you can do in North Carolina. You can put the will on file. You could have the will probated, which means proven with the court, but no actual estate opened. There are small estate administrations that you can do under a certain value in North Carolina. And then there are full probate administrations. The full probate administration is the only one that requires a notice to creditors to be published. If real estate is going to be sold within the 2 to 3 years after your death, because there's different statutes of limitations depending on the type of creditor, then usually a full probate is what makes sense, because otherwise, if no estate is open, creditors have up to 3 years to come forward against your estate. But if you publish the notice to creditors and do a full probate, you can limit that to 3 months. And then if creditors have not filed a claim within those 3 months, then they're forever barred. And so it can be beneficial to do a full probate estate, even if it seems like more upfront hassle. Another question was, if you own property in an LLC, what can be done about that in a will? And so it really depends on the type of LLC and what it owns, and that's a more in-depth discussion. But LLCs can be owned by trusts. You can do beneficiary designations on LLC interests. You could be specific in your will about who gets that LLC interest. You could do a revocable trust, and put it in there. And so there are multiple ways to handle LLC interest to try and make sure they're not part of probate. But if you don't have a trust and you haven't otherwise done something to address that LLC interest, the LLC interest would be part of your probate estate when you pass away. It would need to be valued. It would need to be reported to the court. If it's an operating LLC that's an actual business, there can be reasons why you don't want that to be public record. Lots of considerations depending on the type of LLC and what it's doing. The last question is, actually, there may be one more that just came in. If a house is owned outright and the owner goes into a nursing home or memory care, how do you protect the remaining owner? And how do you protect the remaining land in a separate parcel? And we'll dive into the long-term care piece of that last, but we will address that. Let's see, the last one is, could a special needs trust apply to a disabled adult person not under a guardianship? Absolutely. You can set up a special needs trust for anybody. Special needs trust really is referring primarily to a specific type of distribution standard. So when you set up a trust for someone, you set up the strings of how that money is going to be managed. Does that person have a right to money from the trust for their care and support and maintenance? Or is it 100% up to the trustee's discretion about how that money is distributed? If the trustee has 100% discretion over how the money is used, then it's not going to be countable for Medicaid. And so while the term special or supplemental needs trust is used, it's really referring to that distribution standard, usually with some other provisions that come with a good special or supplemental needs trust. But the key piece there is that distribution standard. Someone asked about repeating the different levels of probate. So you can just put the will on file, which means the courthouse has it, but it's not been proven to the court as a valid will in North Carolina. You can probate the will, but not have any administration. And that's where you pay $30 and file a form with the court. The court says, yes, this is a valid will, it's probated, but that's it. Nothing goes beyond that. There's no actual estate. There is a small estate administration called an affidavit for collection that can be used. And so that's for just, if you have a couple of bank accounts to deal with. There are some smaller ancillary things you can deal with that I'm not going to get into, because again, probate could be its own, hour-long presentation. And then there's a full probate administration. And that's the whole shebang where you're filing an inventory with the court, you're publishing a notice to creditors in the newspaper, you're filing accountings with the court, and it can be beneficial to do that if real estate is being sold fairly soon after death. Another question is, am I responsible for my spouse's credit card debt if your name is not on that person's account? And we get this question from kids a lot too. Am I responsible for my parents' debts? And the answer is probably not. So particularly if it's a child-parent relationship, if you're not an owner on that credit card, you didn't put those charges on there, you're not connected to it, then no. In most situations, you are not going to be responsible for the separate debts of somebody else. That being said, in North Carolina, spouses are responsible to provide for each other's necessary expenses. And so that's food, shelter, medical care, things like that. I suppose if charges were put on a credit card, that were for some of those expenses, and the reason they did it was because you would refuse to pay for things or support it, an argument could be there. But I'll tell you, I don't know that I've ever seen the credit card companies care enough. If we sort of send them a letter that says we're not opening an estate, there isn't going to be one, typically they just write those debts off. I don't think I've ever seen them pursue a claim. And we had one where a spouse put all the charges on the deceased person's credit card. It was probably $23,000. We rejected their claim in the estate because the charges were not put on by the person who passed away, and they didn't challenge the rejection. And so if there is a creditor that you don't think is valid, you can reject that claim when you have a full probate estate, and that gives that creditor 3 months to file a lawsuit to enforce it. And if they don't, then their claim forever lapses. So if there are creditor issues, it can be helpful sometimes to open up a probate estate, but you want to do that with caution. I know that there is this sense that you need to act quickly after someone passes away to do stuff. And sometimes it's helpful to pause a minute and get professionals involved before going down to the courthouse. You don't have to file a will if there are no assets. Mortgage debts and secured debts are different than other debts because they are tied to that asset. So if you own a home that has a mortgage on it and you have a will that says, I leave my house to my 3 children, they inherit it subject to that mortgage. If they don't pay the debt, then the mortgage company could file a claim against the estate. They could foreclose on the home. They can still go after that debt. That debt does not go away. It's different in that they have it secured to a particular asset. Yes, someone asked if there's a recording of the meeting that will be made available. My understanding is yes, we're going to work to make that happen for y'all, and it is a lot of information in one day. All right, I think we're ready to move on to the next slide now.
Someone asked about mortgage debt.
Yeah, I think we addressed the mortgage debt one, that it's, they can file a claim against the estate, but it follows that the secured asset, which is usually a house.
Thank you.
All right, now getting to trusts. So for those of y'all who have heard about trusts, if you've seen anything with Susie Orman, or other folks, you may have heard about trusts a lot. And so it can sound really fancy and complicated, but it's really not. It's one person, or you can name a corporation, that's holding assets for the benefit of somebody else. That's it. So you say, I'm going to name my daughter as trustee to hold assets in trust for the benefit of my 5 grandchildren, and you set out in that document what the rules are about how that money is managed. It can be a really nice way to make sure the assets are protected and used for somebody else. And someone asked if the Susie Orman documents are legal in North Carolina. I have not seen her templates or anything. I don't know if she's state specific about how she develops those, so I'm not really sure about that. A revocable trust, also called a living trust, is the most common that you're going to see in North Carolina. It is not needed for everyone, but can have advantages. So it is an enormous pet peeve of mine when I hear other lawyers say, everybody needs a trust. Go out and get a trust. Everybody needs it. We just talked about wills, and we talked about what wills cover in probate and how you can use beneficiary designations, pay on death, POD, transfer on death, things like that, to avoid probate. So trusts are almost always sold to people as a probate avoidance tool, and they do that. And there can be a lot of other advantages to a trust. But if your only concern is probate avoidance and you have a really simple family situation, then you may not need a trust. And so don't feel like you have to have one, because you may not need to, and if you're working with a qualified estate planning attorney, they will go over your specific situation with you and tell you honestly whether you need it or not. Some of the advantages include management of assets during incapacity. So I talked earlier about powers of attorney and said that they can help reduce or eliminate the need for a guardianship down the road, but it doesn't necessarily eliminate it completely, because there can be situations where someone is unable to manage assets prudently on their own and they're making really bad financial decisions, but they have a power of attorney. And so sometimes you have to have a guardianship to cut off that person's assets. The only way to really take away one person's rights to manage their own assets is a guardianship ordered by the court, where they literally strip you of certain rights. Otherwise, the power of attorney is really you and the person who you've designated working in tandem, potentially, to manage those assets. So sometimes the person whose agent is trying to protect the money and the other person's making poor decisions or being exploited, and a guardianship can be the only way to do that. Trusts are nice because it says if the trustee, presumably you when you set it up, is unable to manage assets due to incapacity, then they can't serve as trustee anymore, and the next person in line serves as trustee. So it can be a good way to, outside of guardianship, make sure that only one sort of person who has proper capacity can manage those assets. It also provides flexibility. So I mentioned that there are benefits to having beneficiary designations, but there isn't a lot of flexibility in that, because you could say, I have a very simple family situation. I have 3 adult children. They're all great. They have stable jobs, stable marriages. I'm not worried about anybody, but you never know when someone's going to lose a job, when they're going to get divorced, when they're going to become disabled. Trust can help build in some flexibility where you could name your trust as the beneficiary and say in your trust, I leave assets to my 3 children, but add in a provision that says if one of these children is in the midst of bankruptcy, divorce, separation, if they are disabled, then their money is going to be held back in a separate trust until whatever that situation is resolved. And so that flexibility can be a nice aspect of the trust. Also, privacy. I mentioned that your will becomes public record when you pass away. Trusts are generally not public record. There may be some pieces that are public, like who's serving as the trustee, if you have deeds or other assets that are involved, but generally speaking, the actual terms of the trust are not going to be public record. Unusual assets, or assets that you want the values to be kept private, like those LLC interests, can be helpful with a trust, because then you're not having to value those assets to the court and report them. And so consider that if you have some assets that might be less common. And then probate avoidance, which we talked about. It's an added benefit. but I don't want y'all to freak out and think you need to run out and get a trust, because there are other ways to avoid probate that don't require a trust. Because a trust, while flexible and can be nice, does add some complication, to your estate plan. There are more types of complex trusts, like irrevocable trusts, which can be used to hold life insurance or assets for asset protection purposes. Irrevocable trust can be part of Medicaid planning, supplemental needs trust for disabled beneficiaries. I'm not going to dive into all of that just in the interest of time, but there are lots and lots and lots of trusts that are out there. Somebody asked what certifications are desired when it's selecting an estate lawyer to prepare a trust and a will. Some folks belong to a legal plan that has a limited selection of attorneys, and I don't know if we should just pick one or find a recommended specialist outside the plan. So it depends on who's listed in the plan. If you want referrals or to see if someone in that area is someone who looks like they would be able to do it, I'm happy to try and help you find someone who's qualified in your area. There are a lot of really, really good estate planning attorneys and elder law attorneys that are not board certified specialists. So the first place to start might be to look for a board certified specialist. So the North Carolina State Bar has a website that lists by practice area different specialists in different areas. So there are estate planning attorneys who are board certified specialists. There are also elder law attorneys who are board certified specialists. So that's a way to sort of go with someone who has sort of been proven by a third party to know what they're talking about and know what they're doing. That's one option for you to take. But if there's lots of qualified folks who are not specialists, you can look on websites and things like that and look and see, has this person been involved in the bar association section? Have they published articles that are about this? Do they speak regularly on this topic? Do you know friends or family members who have used them? That's a great way to find someone who's qualified. I would stray away from people who list every type of practice area on their website. If there's someone who says, I do criminal law, family law, estate planning, elder law, intellectual property law, it is hard to be well-versed in this area and do other things because it does change every year. There's new things that pop up, and you have to be involved in this area of law and sort of follow it to know what those new things are. And so that's, one way to look at it. In terms of the legal service plans, I'll tell you, I and most of the attorneys that I work with do not work with those plans because they usually say, all right, everyone who's on our list agrees to give a free 30-minute consultation. And, then after that, a 20% discount. And so again, all of the attorneys that I know in this practice area are wildly busy. There's not a benefit or a reason to us to discount those services because there's so much out there right now. So just keep that in mind of sort of who is accepting that work and why are they taking that discount when in this practice area, at least there's a whole lot out there. And just for context, because I should mention, how much does it cost to do all of this? The answer is highly variable. I and a lot of the attorneys that I know charge a flat $500 consultation fee. That is like going really in depth in your assets and talking about everything and telling you what we think you should do. It's very specific. And then you get a summary afterward that says, here's everything you should do. There are some attorneys who do free consultations, but in this practice area, it's not all that common. And then in terms of the actual documents, some attorneys charge on an hourly basis, some charge a flat fee. Again, the price is highly variable. For all of these documents, I would expect, depending on if you're single or married, somewhere between $1,200 and $5,000, potentially more if you were doing something really complicated. The $5,000 range is when you're having multiple trusts that are involved, usually fairly custom or complex in some way. And then $1,200 might be like a really, really basic, estate plan for someone who is single and also an attorney who's, maybe 5 years or so into practice or less. So somebody, let's see. The next question is, my stepson is covered in my ex-spouse's will, son and daughter are covered in mine. How can I word my will not to have him challenge my will? So that's a more specific conversation to have. But sometimes having trust involved can be helpful in that because then your will just says, I leave everything to my trust, and your trust is private. And so trust can also be helpful if you think someone might challenge your will. It doesn't keep them from challenging your estate plan, but it can add an extra hurdle to them. Also, if you think someone is going to challenge your capacity to sign documents, then it can be helpful to have doctor letters or formal medical opinions gathered ahead of time. Someone noted that Susie Orman is specific, in the states. You can select which state you're using, but having anything reviewed by a qualified expert is always advised, which is great advice. If the house is the only asset, should we ask an attorney to do a probate without an administration? Depends on whether the house is being sold after your death or not. I am located in Asheville, but I do know a number of colleagues in the Chapel Hill area and the Triangle if y'all need a referral somewhere. And now is a good time to get into sort of what happens if I did documents in another state and I moved. So if you did documents in one state that were valid in that state at the time it was done, they're going to be valid in a new state. So that's due to the US Constitution, full faith and credit clause. States have to honor the laws of other states in almost all areas of law, including this one. That being said, if you've moved from another state, remember early on I said every state can be a little bit different. And so you need to keep in mind that if you are moving from a state with a healthcare power of attorney that looks wildly different than what North Carolina uses, and you are here and plan on staying here, then it can be helpful to update it just so that it's a form your healthcare providers have seen time and time again. They know it, they trust it. There's not going to be a delay in them honoring that document. There can also be practical hurdles with your will. If you did a will in another state that was valid at the time it was done, but that will doesn't comply with North Carolina's requirements, then there is another form that has to be filled out to probate the will in North Carolina. It can require that we pull the law of that state at the time it was done or get an opinion from an attorney in that state. So it can add some delay, it can add some complication, it can add some cost. So it's not that they're not valid, but there are practical hurdles to consider. It can also be a little strange because if you have a Florida will and it's being probated in North Carolina, the Florida will uses Florida laws, and the North Carolina court would be obligated to use the Florida laws that are incorporated in that will. And so that's something they're obviously not used to doing. And so again, it's not a validity problem, it's sort of specific practical hurdles that can be issues. Can a North Carolina lawyer prepare an estate plan for a client who lives outside of North Carolina? Yes, if they're licensed in the other state. If they're not licensed in the other state, but you feel really strongly about working with a particular North Carolina attorney, sometimes what we'll do is pair with an attorney in that other state where we would draft the documents and then have the other person sort of update it for that state or review it and bless it before it's done. Do I recommend the North Carolina Credit Union Planning Services? If you have a simple situation, yes. You are not going to get special needs planning out of that, long-term care planning. That's not part of what they do. But if you are certain you just need simple documents done, then yes, it's a great service and can be a great low-cost option. All right, let's go on to the next slide and try and keep moving. So I think we talked about these other related documents except for the DNR and the most form. DNR is a do not resuscitate. Most form is medical order for scope of treatment. Those are forms you do with your doctor, not your lawyer. And so just if you have questions about when and how to do a DNR form, or if you're appropriate to do a most form, which I always call kind of a cheat sheet for doctors regarding your care, and it's a little bit more detailed about the medical aspect of things than your living will, talk to your doctors about that. All right, let's go on. I did have a slide for this. What if I did estate planning documents in another state? Again, valid, but there are practical hurdles, and a qualified attorney in the new state can always review those documents for you and tell you about those limitations. And with almost everything in estate planning, it's not a right or a wrong. It's about just being informed and making affirmative decisions about what you're going to do next. All right, so decisions. So what's the right time to start an estate plan? And the answer is now. So I completed my first set of estate planning documents when I was 18 because I'm a paranoid person and that's how I go. And my mom passed when I was fairly young. And so, I knew that this was something that was important and have redone those documents several times since then. I started out having them done by a lawyer and continued to do that until I became a lawyer, and then I did them on my own. You have to be over the age of 18. And again, consider working with a qualified professional, especially if you have special circumstances, a few of which are outlined below. And you're going to kind of know, I'll also say you're going to have a gut feeling about the person you're working with. If you do not trust that person, if you do not have a good rapport with them, then find somebody else. Because I talk to a lot of clients who say, oh, I didn't understand any of what this old estate plan said, but I didn't feel comfortable asking that person questions. That is not the right relationship for you. You need to feel comfortable with the professionals you're working with and be able to say, I have no idea what you just put in front of me, and explain that to me. You need to be given time to look at those documents ahead of time, to consider them and understand them, because it is shocking the number of people that I meet who have no idea what their estate plan says and no idea what's supposed to happen when they pass away. And so, again, there are lots of really good lawyers out there in North Carolina who do this type of work. Make sure you're working with someone that you're comfortable with. And a lot of lawyers, myself included, will offer to do free, like brief meet and greets with people, so that there's 15, 20 minutes just to sort of find out about the process and say, personality wise, are we on the same page? Is this something that makes sense? And also in terms of sort of special qualifications, what makes sense. You know, the way my firm is set up and my estate planning peers at my firm is that each of us kind of has a different area that we focus on. And so if you are ultra high net worth and you have multiple family businesses and you need a family business succession plan, I am not the person for you to work with. But I have two colleagues down the hall who have great tax expertise, who are able to help with that and help with those specific details. And so you want someone who knows their practice area, who knows their own limits, and can make sure you're with the right professional if they are not it. Let's go on to the next slide. All right, so how do I select trustworthy agents and fiduciaries? Pick the people who are going to make decisions for you the way you would make them for yourself. And so it is really concerning how many people say, oh, well, I picked Tom because he's my oldest son, or I picked Amy because she's the most sensitive and her feelings are going to get hurt if she's not named first. This is not the time to worry about other people's feelings. You need to make decisions based on what's best for you. And again, it used to be that people sort of looked at this role as, I'm going to make decisions based on, you know, what is in the best interests of the other person. And that thinking has shifted to, I'm going to make decisions based on how they would make decisions for themselves. So that could include, the most common thing I see is people who say, well, mom needs to go to assisted living, but you know that mom wants to be at home. And maybe she's not totally safe at home and would be safer in assisted living, but maybe there are some technologies we can employ or caregivers that we can have at home that make it safer, at least safer to an acceptable level, even if it's not as safe as assisted living. You know, sort of honoring what that person wanted as they aged or as they declined, and making sure that you can keep with their wishes as best you can. Next is consider the strengths of potential candidates and their financial experiences. And so that's another thing, is that people, you know, sort of will say, well, I'm going to name my son Randy because he lives with me. And then they start telling me about how Randy had a really nasty divorce, and part of it was because of his gambling, and Randy has a lot of credit card debt. Oh, and he's in the middle of bankruptcy, and he has a lot of outstanding child support. You know, people who are financially exploited, you know, don't need to, you know, people who are financially exploited typically would think that they're going to be exploited by somebody who has really, really bad intentions against them, but that's not the case. A lot of times it's just temptation and people seeing a need and saying, I'm going to borrow this money and I'm going to pay it back. Or the individual would want me to have this money. They want to help me. It's not sort of this nefarious kind of movie character that you might think of. It's people who are loved ones who don't necessarily mean any harm, but they still make bad decisions. You can add some protections for yourself in the documents. And another thing to be helpful to selecting trustworthy people is organize ahead of time, literally and figuratively. Organize your estate plan by doing these documents. If you need professionals involved, whether it's a care manager or a private agency to help serve as your agent, get that lined up ahead of time and make sure that things are actually physically organized in your home so that that financial information can be found. We'll go ahead on to the next slide. And how do I finalize these goals? Tell people to work backwards. What legacy do you want to leave behind? Are there particular organizations and causes that you want to benefit? Consider the circumstances of those who will receive the assets, like if they're disabled. If a family member needs a trust, consider just how much you want to control things from the grave. And remember that estate planning is not one size fits all. There's rarely a wrong choice. And so you need to just think about your personal situation and what you want to do. All right. And so lifetime philanthropic giving. So there are lots of ways, if you are charitably inclined, to include those organizations in your estate plan. And so that can be outright gifts, which are the simplest, just saying I'm going to leave $20,000 to this organization. You can bunch gifts into years so that you can itemize deductions. And so you could say, I'm not going to give this year, but I'm going to give $20,000 next year because I'm going to be able to itemize next year and sort of capture that and give larger gifts in bunches. You can also do a donor advised fund through your local community foundation. And certainly it's great to talk to them. And that gives you flexibility to set up a sort of charitable entity. Think of it kind of like a trust, even though it's not. You make contributions to that, but that setup, that fund can be a lot more flexible where you say, I want to benefit PBS North Carolina and NPR, and choose sort of groups or types of organizations to benefit. You can make gifts from IRA distributions. And so if you have RMDs, required minimum distributions, that are coming out, you can direct those over to a nonprofit organization and you are not taxed on the portion that you direct over to the nonprofit organization, as long as you meet certain requirements and limit it to $100,000. You can gift appreciated assets to nonprofits. And so that can be a good way to get some benefit on capital gains. And then you can also use some more complicated methods like charitable gift annuities, where you set money aside in an annuity, and then you can get sort of income payments from that. And then the principal ends up with the nonprofit, and there's a lot of tax advantage to that. All right, next slide. And I know we're running right on 12. And so we're going to start wrapping up soon, but I'll work ever so quickly through this. And sorry, we had so much material to cover. I sort of listed, some of the other options you can do when you pass away. And IRA beneficiary designations. If you give traditional IRA funds to a nonprofit, they get that money tax-free. So if you want to benefit a charitable organization, that is the best vehicle that you can do it. If you have traditional IRAs, is to just give it to them, because it's going to be so much more bang for your buck to that organization. All right, ever so briefly, long-term care considerations. If you or a loved one has been diagnosed with a progressive illness, you want to be prepared for long-term care in the future, consider asset protection and benefit planning options. There are things you can do. There are things you can do that don't require breaking the law. It's all squarely within Medicaid rules, because Medicaid is set up, particularly if you are married, to make sure that if one spouse gets sick, the other one does not become impoverished and they end up on public benefits because one person happened to get sick first. So there are ways to protect homes, pieces of property that are adjacent to your home, other pieces of property that you own that are not connected to your home. There are a lot of options there. Medicare is not intended to pay for long-term care. So if you're under the misconception that Medicare is just going to pay for long-term care, they don't. Medicaid planning does not require that you need to be really wealthy to do fancy trusts ahead of time, or that it requires hiding assets. There's 3 eligibility criteria for these programs: medical need, income, and assets. And again, the options are very flexible for married couples. And if you think that you want to plan for long-term care, even if you don't have a diagnosis of something, then you need to find a qualified elder law attorney in your area. Again, you can look for a board certified specialist, or if you want a broader search, NALA, the National Academy of Elder Law Attorneys, has a directory on their website that you can go to. And so they can help you find somebody in your area, or again, I'm happy to refer you to someone in your area that's qualified. All right, and that's it. So thank you so much for joining me, and I'm going to let Warren and Tanya help wrap us up now. And sorry we didn't have more time to focus on some of the material, but y'all have been a great audience.
Thank you, Kathleen. I'm sure we could probably go on a good while longer, but you might need to start charging, I think, at this point. So thank you so much. That was excellent. A lot of great questions and a lot of great insights from you today. Thank you so much. We really appreciate that here at PBS-NC. We will send an email out to all the participants, and in that email, we'll have the slides for Kathleen's presentation today. That sound right, Kathleen?
Yeah, it'll have the slides, and there's like sort of an outline summary, and then a handout about charitable giving.
So you'll get that material. You'll be reminded how to contact us. You'll be reminded how to contact Kathleen. And regarding a recording, we're still working out details as to when and how we can best share that. So stay tuned. You may get a second email regarding that. We just aren't sure yet, but we're still working on that. So again, thanks everyone for coming, and stay tuned, as I like to say. Thanks everyone. That's it from me. Tanya, any last wrap up?
No, but thank you all for tuning in. We really do appreciate being able to bring this service to our loyal viewers and members.
Hear, hear.